Thank you, Your Honor. My name is Elizabeth Kuhn, and I represent Ms. Jody Avren. This is a domestic relations case, and I think the most important thing that we need to realize as I go through some of the procedural parts of my argument is that at the end of the day, we have a little boy, Brandon Garten, who is about to be 12, or excuse me, is now 12, and will be 13 this September. What I believe this court has asked me to do, we have the first appeal, which is direct appeal because it concerns custody of a child. Then there is a subsequent appeal with a motion to set aside an order of attorney's fees arguing supersedis, and that motion was denied and the subsequent appeal followed. This court specifically asked me whether that was subject to a direct appeal or whether that was subject to the discretionary application procedures as it relates to 9/11/60. I submit to this court that 9/11/60 is subject to the discretionary appeal process, and I do agree with my brother that that is a discretionary appeal process. However, I do want to point out to the court that particular order which issued an award of attorney's fees in a contempt action, a dismissal of a petition for modification action, that supersedis applied. That being, supersedis is a general rule of this court, and I believe that my brother is trying to argue an exception to the rule, and I would like to point the court to two cases, specifically the supersedis issue in an opinion by Justice Hunstein in Panaris versus George, which was cited, 284 Georgia 483, and this is actually a case in 2008 that was brought by Mr. Webster arguing my side of the case. This court, in the same and similar circumstances, held the record reveals that after the Panaris filed her application to appeal, the trial court issued two orders, one purporting to deny motion for reconsideration and award additional attorney's fees, and the other purporting to vacate its original order on the contempt motions. And this court held the trial court lacked jurisdiction to issue these two orders due to the pendency of the application for appeal. And in this case, it's our position that the court erred in awarding those attorney's fees. The court should have stayed the issue of attorney's fees. I'm not saying the court doesn't have the authority or the jurisdiction to eventually order, but we needed to see what happens in this appeal. Those attorney's fees specifically relate to the issues on appeal, which is the contempt and the denial of Ms. Avren's petition.
In this particular case, did not the trial court reserve the attorney fee issue at all?
Yes, Your Honor. In this case, the trial court did reserve the issue of attorney's fees, and that is proper. Had the court issued an award of attorney's fees, the court could have said pending the outcome of the appeal, or this order is stayed pending the outcome of the appeal. Unlike other cases where this court has carved out exceptions, this is not an attorney's fee issue that stands independent, and I believe that's what the crux of the issue is with regards to the supersedis.